The BVI Court System, a Q&A guide. The BVI has established a reputation for maintaining an independent and highly respected court system for the resolution of high-value commercial disputes. The courts benefit from adherence to common law principles and the appointment of experienced judges, whose expertise ensures that proceedings are conducted in accordance with internationally recognized standards of fairness and legal rigor. This, combined with a well-developed body of commercial case law, guided by English and Commonwealth authority, has made the BVI a trusted jurisdiction for resolving complex cross-border disputes. The BVI court system has established itself as a global hub for commercial and insolvency-related matters and trust litigation. With over 355,000 active business companies registered in the jurisdiction, the sheer volume of BVI-incorporated entities used in international corporate and fund structures means cross-border commercial disputes and insolvencies frequently have a BVI nexus. The BVI Insolvency Act 2003 provides a robust framework for recognizing foreign proceedings and assisting foreign representatives from prescribed jurisdictions. What is the structure of the courts in the BVI? The BVI courts form part of the Eastern Caribbean Supreme Court (ECSC) system. The civil court hierarchy comprises A. The High Court, Civil Division, B. The High Court, Commercial Division, C. The ECSC Court of Appeal, and 4. The Judicial Committee of the Privy Council in London, which sits as the final appellate tribunal. Procedure is governed by the ECSC Civil Procedure Rules 2023, ECCPR, and associated practice directions, which are based on, but not identical to, the England and Wales Civil Procedure Rules. Are any pre-action steps required before issuing proceedings? Whereas the BVI Court does not have the extensive system of pre-action protocols found in England and Wales, Practice Direction 8, number 2 of 2023, introduced protocols requiring parties to share relevant information prior to commencing a claim. The objective is to facilitate early exchange of details, promote settlement, and ensure any subsequent litigation is managed efficiently. A claimant is expected to write to the defendant outlining the claim, and the defendant must reply within an agreed period, either accepting or contesting liability. Failure to comply may attract adverse costs consequences, save where urgency applies or a limitation period is about to expire. The court nonetheless expects parties to act reasonably and promptly in exchanging documents and information, and in attempting to avoid litigation. How are claims initiated? The method depends on the nature of the dispute. Part 8. Claims. Part 8 of the ECCPR governs the commencement of proceedings in the BVI and applies to all claims as the default procedure. The claimant files a Part 8 claim form together with a statement of claim, setting out a short description of the claim, the remedy sought, and an address for service. There is no monetary threshold for commencing a Part 8 claim, as such, although claims proceeding in the BVI Commercial Division must have a minimum value of $500,000. Once the claim form is served, the defendant has 14 days to file an acknowledgement of service and 28 days to file a defence. The case then progresses through a case management conference, disclosure, witness statements, and expert evidence, typically spanning 6 to 18 months. With complex commercial trials usually listed within 18 to 24 months of filing. Fixed date claims. A fixed date claim form is designed so that a hearing date is allocated at the point of issue. If the claim is undefended, or the court considers it suitable for summary determination, this initial hearing may be treated as the trial itself. The claim is supported by affidavit evidence rather than pleadings. Examples of matters requiring a fixed date claim form include recognition and enforcement of foreign arbitral awards, restoration of a company, rectification of a register of members, Beddoe and Public Trustee versus Cooper applications, probate claims, and schemes of arrangement. What is the typical time frame from filing to trial? Timelines vary considerably depending on the complexity of the matter. Urgent applications, accompanied by a certificate of urgency, may be resolved within days or weeks. More involved disputes can take around a year to progress from filing to trial, though expedited listing is possible in some instances. Trials follow the common law model. Counsel presents oral argument and examines witnesses of fact and experts before a single judge at first instance. Parties may apply for a virtual hearing in exceptional circumstances, provided the request is made no later than 7 days before the scheduled hearing date. Can court filings be submitted electronically? Most documents are filed through the ECSC's e-filing portal, which is available to BVI legal practitioners. The court registry is responsible for assigning matters to judges, scheduling hearings, and issuing approved and sealed court orders. Is there a right of appeal? Decisions of the High Court are appealable to the ECSC Court of Appeal. The Court of Appeal sits in the BVI 3 times per year, although BVI matters may sometimes be heard remotely by the Court of Appeal, sitting in other ECSC jurisdictions. What are the timelines and procedures for appeals? A party has an automatic right of appeal to the Court of Appeal from a final decision of the High Court, that is, no leave to appeal is required. Whether a decision is final is assessed using the application test, that is, whether resolution of the application would have conclusively determined the litigation irrespective of outcome. Similarly, final decisions of the Court of Appeal may be appealed as of right to the Privy Council where the disputed matter is valued at a minimum of £300 or involves a claim to or question regarding property or a right of at least that value. Interlocutory decisions resolve specific procedural issues or provide interim relief, such as specific document disclosure or an injunction, but do not determine the final outcome of the case. Leave is required to appeal an interlocutory order of the High Court, except in the case of certain exceptions, such as the grant or refusal of an injunction or the appointment of a receiver. Leave to appeal is discretionary. The applicant must show reasonable prospects of success or other compelling reasons. Public interest considerations such as uncertainty in the law or a novel legal point may justify the grant of leave. If the Court of Appeal's decision on an interlocutory matter is challenged, leave to appeal to the Privy Council is required. Leave will be granted where the question is of great general or public importance or other compelling reasons exist. Where the Court of Appeal refuses leave, an applicant may seek special leave directly from the Privy Council. Is interim relief available? Interim relief applications are common in BVI proceedings, and the BVI court has broad powers to grant injunctive or other protective orders. In urgent cases, particularly where giving notice might undermine the purpose of the application, relief may be sought on a without notice, ex parte basis. Key forms of interim relief include freezing orders. These restrain a respondent from disposing of assets, whether within or outside the jurisdiction, or from removing assets from the BVI. The applicant must demonstrate a good arguable case, b. a real risk of dissipation of assets, and c. that it is just and convenient to grant the relief. Since the introduction of Section 24A of the Eastern Caribbean Supreme Court Virgin Islands Act and the Privy Council's decision in Convoy Collateral, standalone freezing orders in aid of foreign proceedings are available in appropriate circumstances. Interim receivership orders. These can be granted inter alia when there is a measurable risk a freezing order would be ineffective. Anti-suit injunctions. These restrain a party from commencing or continuing proceedings in another forum where it is convenient to do so, with the court weighing relevant factors on the particular facts. Prohibitory injunctions. These prevent a respondent from acting in a specified manner where a. there is a serious question to be tried, b. damages would be an inadequate remedy, and c. the balance of convenience favours granting the order. Proprietary injunctions. These protect property and trust assets, applying the same principles as prohibitory injunctions, provided the applicant can establish a proprietary interest in the relevant asset.